It is important to ensure schools are FERPA compliant. To do this, schools must make sure that employees are aware of FERPA and understand it is their duty to comply. Employees should know the rights, protections, and the exceptions. So what does FERPA stand for? FERPA stands for the Family, Educational Rights, and Privacy Act. Its purpose is to protect student records in K-12 schools as well as post-secondary educational institutions. FERPA provides a student's legal guardians, a student over the age of 18, or a student enrolled in post-secondary education the right to inspect and receive educational records. It also provides the right to deny the access of these records to others. Along with these rights, FERPA also provides a process to correct errors to the record, the right to opt out of military recruitment, the right to opt out of disclosing directory information, and offers a complaint process if a violation of these rights has been suspected. FERPA prohibits the release of educational records without consent of parents or of an eligible student. The Family Policy Compliance Office in the Department of Education is responsible for administering FERPA and for investigating complaints that are filed. A question you may be wondering is, what exactly does educational records entail? FERPA covers anything directly related to the student that is kept by the school or by a third party acting for the school. This includes ACT and SAT data collected during testing, as well as a teacher's gradebook. This does not include directory information, notes written by a teacher for personal use, or records kept by campus security. Educational record information includes student grades, disciplinary records, attendance reports, and physical or academic test results. The Houston Independent School District has also included student name, the name of any family members, and the parent's address as personally identifiable information that cannot be disclosed without consent. Directory information can be disclosed without consent as long as schools provide public notice to families that explains what types of information are designated as directory information. Directory information is personally identifiable information that is not considered to be harmful if it's disclosed. Some examples include a student birthday, grade level, or their enrollment status. If you are ever unsure about disclosing information, talk to the administration team. There are various items for individuals working in all levels of education to consider and follow in order for the school to be FERPA compliant. It is very important to be aware of what is written in contracts with vendors, especially if the vendor is free. Free vendors have a tendency to entail data mining, and this is a violation of FERPA. Ensure third-party vendors have the appropriate safeguards in place. It should be clear that all data belongs to the school and that it is the vendor's responsibility to process the data for the school and student benefit. When a parent or eligible student requests a record, provide it. Schools are not required to provide them with a new copy, but this is an option. Do not disclose educational records without receiving written consent from the parents of the student whom the records directly relate. This includes video surveillance recordings kept by the school that the student is a participant in. Schools have a duty to keep and maintain access logs of all educational records. The logs need to include the reason for access. Only parents and school officials may view the access log. All school employees need to permanently and irreversibly destroy records when they are no longer needed for the purpose the information was gathered. If a school is keeping surveillance recordings, it is also their duty to disclose this information to parents as it has become part of the student's educational record. The following are examples of FERPA violations: denying a parent access to their child's records or denying an eligible student access to his or her own records. Inappropriate disclosure of student information, especially on social media where it can be disclosed to hundreds or thousands at a time instead of just one person. It is also a violation to post graded work in the hallway or to post student information or pictures on the internet without consent. Schools cannot provide surveillance recordings of students to anyone without written consent from the parents of whom the recording directly relates. They also cannot provide ICE with student records of any kind without written proof of a legally mandated basis, such as a valid court order or subpoena. If a parent or eligible student feels a violation has occurred, they can file a formal complaint with the Department of Education. Each complaint is considered on a case-by-case basis to determine the best steps for resolving the underlying situation. The most effective response to accidental violations is for the department to assist in improving policies, practices, and security measures to help prevent future occurrences. If a school is unwilling or unable to make the steps needed to be in compliance, the department will withhold federal funding, although at this point that has never had to have happened. There are several exceptions to be aware of. The Department of Homeland Security and its ICE Bureau have the right to access educational records in order to monitor the stay of international students who are part of the Student Exchange and Visitor Information System program. If disclosing records is necessary to protect the health and safety of a student or person in connection to the information during an emergency, then the schools may do so. Student educational records can also be shared with designated personnel and law officers in an event of epidemic, disease outbreak, or a campus shooting. Generally, schools must have written permission from the parent or eligible student in order to release any information from a student's education record. However, FERPA allows schools to disclose these records without consent to the following parties or under the following conditions: the school officials with legitimate educational interest, other schools to which a student is transferring, specified officials for audit or evaluation purposes, appropriate parties in connection with financial aid to a student, organizations conducting certain studies for on behalf of the school, accrediting organizations, to comply with a judicial order or lawfully issued subpoena, appropriate officials in cases of health and safety emergencies, and state and local authorities within a juvenile justice system pursuant to specific state law. Classroom teachers have a duty to protect their students. Some tips to ensure student safety under FERPA within the walls of the classroom include not using websites that ask for personal information from students, to pay close attention to access requests for your students to ensure that you are disclosing information only to those who should have access, keep student data secure, and continually evaluate the technology programs that are being used within your classroom. If you have any questions, check out the HISD Operating Guidelines on Student Records.